Welcome to Nyay Pathsala. Today, we'll explore how leading questions under the Indian Evidence Act 1872 play a critical role on the outcome of trials. Leading questions shape the narratives in our courts. Why? Because leading questions can both clarify and complicate testimony. So let us understand what does leading question means. Leading question, as its name indicates, is one which leads the witness up to the desired answer. Leading questions are one which is put in such a way as to suggest to the witness the answer which is expected or wanted. In cross-examination, the defense counsels always use leading questions to check the credibility of the witnesses and also for the ascertainment of the truth. Leading questions are those questions which suggest to the witness the answer which the defense counsel desires that he should give. If the questions are asked by the defense counsel and the answer is either yes or no, then it would be conclusive and they would certainly be objectionable in examination in chief, but not during cross-examination. There is no particular form which makes a question leading. We must remember that there is no particular form which makes a question leading or will save it from being a leading question. The fact that a question is put so as to require a categorical answer doesn't necessarily mean it is leading. If the questions are prefaced by whether or not so as to avoid a categorical answer, then it saves it from leading. So let us look into some of the examples of the leading questions. As a defense counsel in cross-examination, suppose a question is put like, I know the name of the witness, but still I ask him, is not your name Mr. A? Do you reside in such a place? Are you not in the service of such a person? Have you not lived so many years with him? So these are some of the examples of leading questions. And from these questions, it is clear that under this form, every sort of information that is conveyed to the witness is in disguise. Normally, as a defense counsel, I will use the leading question to prepare the witness to give the desired answers to the questions which I am likely to put him during further cross-examination. I, as a cross-examiner, may pretend ignorance, and it may look like that I am asking for information from the witness. But in reality, I am trying to receive it instead of asking for information. A question is leading which suggests to the witness which he is to make. Or as a defense counsel, I will put it into his mouth and I will want him to reply back in the way that I want. That will be leading questions. Let us understand a leading question by way of an example. When a witness is called to testify of an alleged assault on A by B, and the examiner asks him, did you see B take a stick and strike A? Or did you not hear him say this? These are examples of leading questions. Leading questions, normally we understand that it calls for a simple yes or no. But a question that calls for a simple yes or no is not leading. It is a question assuming expressly or impliedly a material fact not testified, to which points out the desired answer to enable the witness to affirm such fact. So we should remember that leading questions are by no means limited to those which may be answered by yes or no. Leading questions are normally the prerogative of the defense counsel. Or sometimes in a criminal trial, the public prosecutor who calls the witness may also ask leading question. But before that, with the permission of the court, the witness has to be declared hostile. So if any leading question is put by the public prosecutor during examination in chief of a witness, it has to be objected by the defense counsel. If it is not objected, then it will go into evidence. So the court also must see that the leading questions are normally not put to the witness, but if it is put, the defense counsel should be alert enough to oppose it. But there are circumstances where when the examination in chief is done by the public prosecutor, leading questions at that time may be put on certain types of matter, like say introductory matters, such as the name of the witness, the place where he lives, his age, profession, etc. Those type of leading questions can be put. So let us understand the concept of leading question as outlined under section 141 to 143 in chapter 10 of part 3 under the Indian Evidence Act 1872. Section 141 of the Indian Evidence Act defines a leading question as any question suggesting the answer which the person putting it wishes or expects to receive. Similarly, section 142 of the Indian Evidence Act states that leading question must not be asked in examination in chief and re-examination without the permission of the court. Section 142 also lays down that the court should permit leading questions in examination in chief or re-examination only as to the matters which are introductory or beginning and which are unchallenged or which are already been sufficiently proved in the opinion of the court. So let us understand when leading questions should not be asked. Section 142 clearly states that if objected to by the adverse party, leading questions must not be asked in an examination in chief or in a re-examination except with the permission of the court. So, when do you ask leading questions? The answer to that you will find in section 143 of the Evidence Act. Section 143 of the Evidence Act says that leading questions may be asked in cross-examination. Leading questions may be asked in the examination in chief about matters of record. Suppose you want to exhibit an FIR, then you can ask a leading question to that. But sometimes the public prosecutor also has the right to put leading questions. But prior to that, the witness has to be declared hostile by the court. In this regard, kindly look into section 154 of the Indian Evidence Act, which gives the power to the public prosecutor who calls his witness to cross-examine him. Under section 154 of the Evidence Act, the person who called the witness, and if he doesn't support the proceedings, then he can be declared as hostile with the permission of the court. And once a court declares a person as hostile, the other party is permitted to cross-examine him in examination in chief. So, to what extent the statement of a hostile witness can be examined? The right to cross-examine normally is given to the defense counsel. But if the public prosecutor calls a witness and he doesn't support the version of the public prosecutor, it doesn't mean that he is to be declared hostile. The legislature has not used the word hostile in the Indian Evidence Act. But this is by practice. We say that if the public prosecutor's version is not supported by the witness which is called by the public prosecutor, then he is declared as hostile. A leading questions, we must remember, can be asked in section 154 in examination in chief when the witness is declared hostile by the court, and he can be permitted to be cross-examined by the public prosecutor by bringing to his attention the statement recorded under 161 CRPC, and subsequently when the investigating officer comes, he can put that part of the statement to the IO. In the case of Manu Sharma versus State and City of Delhi, reported in 2010 6 SCC page 1, the Honorable Supreme Court held that not every leading question invalidates a trial. Their importance must be assessed based on the facts of each case. The public prosecutor is entitled to put clarificatory questions, as I have already discussed. And those questions can't be termed as leading questions favoring or eliciting answer favoring the prosecution. The other case which you should read is that Varke Joseph versus State of Kerala. It was reported in 1993 Suppli 3 SCC 745 and especially paragraph number 11. In that case, the Honorable Supreme Court held in paragraph number 11 that leading questions is one which indicates to the witness the real or supposed fact which the prosecutor or plaintiff expects and desires to have confirmed by the answer. The Supreme Court observes that leading question may be used to prepare a witness to give the answers to the questions about to be put to him for the purpose of identification or to lead him to the main evidence of fact in dispute. The next observation of the Supreme Court was that the attention of the witness cannot be directed in examination in chief to the subject of the inquiry or trial. But the court may permit leading questions to draw the attention of the witness which cannot otherwise be called to the matter under inquiry, trial or investigation. In regard to the discretion of the court, the Supreme Court says that the discretion of the court must only be controlled towards that end, but a question which suggests to the witness the answer the prosecutor expects must not be allowed unless the witness with the permission of the court is declared hostile and cross-examination is directed thereafter in that behalf. Therefore, we must remember that as soon as the witness has been conducted to the material portion of his examination, it is generally the duty of the prosecutor to ask the questions to the witness to state the fact or to give his own account of the matter, asking him speak as to what he had seen. The defense counsel must be very alert to see that the prosecutor is not allowed to frame his question in such a manner that the witness, by answering merely yes or no, will give the evidence which the prosecutor wishes to elicit. He must be alert to see that the witness must account for what he himself had seen. Section 145 and 154 of the Evidence Act are intended to provide for cases to contradict the previous statement of the witness called by the prosecution. In our earlier video, we have already discussed Section 143 and 154, which provides the right to cross-examination of the witness by the adverse party, even by leading questions to contradict answers given by the witness, or to test the veracity, or to drag the truth of the statement made by him. Under those circumstances, the adverse party is entitled to put leading questions, but Section 142 of the Indian Evidence Act does not give such power to the prosecutor to put leading questions on the material part of the evidence which the witness intends to speak against the accused, and the prosecutor shall not be allowed to frame questions in such a manner to which the witness answer merely yes or no. But he has always a right to give evidence which he has witnessed. So let us summarize what is leading question. We all should remember that leading questions are the prerogatives of a defense counsel. Leading questions should not be allowed to be asked in examination in chief or re-examination. If a public prosecutor asks leading questions, then the defense counsel must be allowed to object to it. If it does not object, that part of the evidence will go. But suppose a public prosecutor calls a witness and he gives a version which is completely different from what he had given when his statement was recorded by the police under Section 161 of the CRPC. Then with the permission of the court, that witness can be declared as hostile and the public prosecutor may be allowed to put leading questions. And later on, when the investigating officer comes to testify in the court, then his attention will be drawn to that part of the statement which was made by the hostile witness in court as well as under 161 CRPC. Leading questions is a very important tool in the hands of a defense counsel. As a cross-examiner, one should be very careful that he should not ask questions the answer which may damage his case. Sometimes a simple yes or no can have a disastrous effect on the outcome of a trial. So we need to understand this concept of leading question, especially from section 141 to 143 of the Evidence Act, which deals with leading questions, and section 154 of the Indian Evidence Act, the procedure prescribed therein. These are important concepts which we should remember while understanding the topic of leading questions. Today, with this, I conclude my lecture on leading question. I sincerely appeal to all of you that if you like our lectures in Nyay Pathshala, then kindly do subscribe to our channel and put your comments as to how we can improve to better our understanding of law, or to explain the various concepts of law which are troubling the minds of the young lawyers. With these words, I take leave from you today and hope to see you soon in the next episode of Nyay Pathshala.